Hello, my dear students. I am Dr. Manoj Sharma. Today, we shall be discussing the topic Consumer and Anti-Dumping Law. We will start with a quote published in The Economist in 1988. Anti-dumping suits are emerging as the chemical weapons of the world's trade wars. This quotation depicts the real picture of anti-dumping strategies being employed by various nations of the world. In this context, the question before us is whether this chemical weapon is useful for the consumer or whether it works against the consumer. Another question is regarding the real impact on the consumer, directly and indirectly, of the anti-dumping measures undertaken by the governments. Before we start with the interface between consumer and anti-dumping law, let us first briefly introduce dumping and anti-dumping. Introduction. The advantages of free trade in the fast-growing global economy are indisputable. Producers benefit by accessing broader customer bases, resulting in more sales and profits. Consumers benefit from reduced pricing and a wider range of product options. Therefore, free trade is useful for both the producers and consumers in an ideal setting. In this setting, we need to understand the dumping and anti-dumping laws and their impact on free trade, consumers, and other stakeholders. Let us consider anti-dumping law and justification for anti-dumping law. As we understand, dumping is defined in the context of international trade to cover situations when the exporter sells goods in the domestic market of another country at a price less than the price charged in the exporting country, or sometimes even less than the cost of the goods. This practice is being adopted with varied objectives, including gaining a competitive edge in a foreign market, predatory pricing to eliminate competitors in the foreign market, or dumping the surplus inventory. Such activities were perceived as dangerous or fatal to local producers, and with the view to protecting the local production entities, anti-dumping policies were adopted. Anti-dumping laws and policies entail the identification of dumping and the imposition of anti-dumping duties or counter-dumping duties in a manner to bring the price of the imported produce equivalent to the normal value or the domestic price, as the case may be. It is required to be noted here that the imposition of anti-dumping duties is on producers, exporters of specific products from specific territories, and these are not general taxes and duties for revenue generation. Whatever the justification and the impact of anti-dumping policies, it is indisputable that anti-dumping laws hinder free trade. The anti-dumping law provides a justification for the ban on dumping for a wide range of social and economic reasons, including but not limited to protecting local producers and ensuring distributive justice. Before we proceed further, it is important to understand the distributive justice argument advanced for the imposition of anti-dumping duties. Distributive justice refers to the socially equitable distribution of benefits and resources among the members of a community. In order to protect the interests of weaker members of the WTO and to ensure distributive justice between rich and developing nations, anti-dumping measures were included in the General Agreement on Trade and Tariff, which is GATT. Anti-dumping regulations were first included in international regimes with the intention of eradicating national market imbalances and promoting distributive justice. The goal was to protect home industries in developing and less developed nations from the business practices of international corporations operating in highly industrialized states. Ironically, though, the most developed industrialized countries have been the ones to use anti dumping laws most frequently, and they have done so to defend some of the biggest companies in the world. Based on the available empirical data, it appears that developed economies such as the United States, Australia, Canada, and the European Union have been the most frequent users of anti dumping measures, accounting for over 90% of cases throughout the 80s and 90s. Consequently, wealthier countries were using anti dumping laws as a weapon, which naturally hurt emerging nations. Consequently, it demonstrates that even though anti dumping laws were included in the GATT with the goal of protecting the interests of WTO's weaker member nations and ensuring equitable distribution between developed and developing nations, they have primarily been employed by major industrial economies. Now, we move on to understand the effects of anti dumping measures on consumers and other stakeholders. The adoption of anti dumping measures by importing nations has both deliberate and inadvertent outcomes. Although intended to safeguard domestic sectors against unjust competition, these policies can significantly impact consumers, market dynamics, and trade patterns. Take an example. Let us suppose I am a manufacturer of insoluble sulfur in XYZ country and I want to gain a competitive edge in Indian market. So what I do? I export my products to India at a very cheap price, say rupees 100 per packet, whereas I am selling the same in my native country at rupees 150 per packet. It may also be that my cost is 110 per packet, but I am exporting the same to India at rupees 100 per packet. An example of the influx of inexpensive imported goods, specifically from China, can also be taken here, which it is claimed has marginalized Indian manufacturers, prompting the need for anti dumping policies for safeguarding domestic producers. On the face of it, it appears that this is great news for the consumers in India because they will be able to buy similar goods at a price that is much cheaper than the price of the goods available in the domestic market. Hence, if the government does not intervene by imposing anti dumping duties, the consumers are seemingly at an advantage. But the big question is whether it is advantageous in the long run to the consumers. Now, see the other side of it. Let us suppose the cost for Indian producers is rupees 130 per packet and they are selling the product at rupees 150 per packet in the Indian market. Now, in these situations, the consumer, of course, gets the product at a much cheaper price in India. But what about traders? How would they deal with this? What will happen in the long run to the domestic production industry? Here, the producers are seemingly left with no choice but either to suffer losses by reducing their prices or refuse to lower the prices. In both cases, the producers are going to suffer. They will become unsustainable in the long run due to piling up of losses, and in the second case, they run the risk of decreasing demand for their products due to higher prices and ultimately economic death for the enterprise. Here, in the long run, the domestic production will fall or even stop. and the foreign entity will gain complete control over the domestic market. And now they can charge whatever price they wish to charge because domestic consumers will have no other option. Further, the downfall of industrial production activities is bound to increase unemployment in the domestic market. It is clear, therefore, that there is a dichotomy between the interest of the producers and the interest of the consumer when it comes to anti-dumping regulations. But the bigger question is whether protecting domestic producers really helps the consumers in the long run. Upon cursory examination, the advantages of anti-dumping measures are evident. Importing countries implement tariffs on dumped imports to achieve market equilibrium and discourage foreign producers from selling goods at lower prices than domestic producers. Nevertheless, consumers bear the burden of this since they are deprived of the advantages of reduced costs and heightened consumer surplus. Imposing anti-dumping duties causes the price of imported products to increase until it reaches the same level as the price in the domestic market. This results in a reduction in supply from foreign manufacturers, leading to suboptimal levels of output. Consumers are compelled to bear elevated expenses, resulting in a decrease in their consumer surplus and potentially causing some to exit the market entirely. Furthermore, the implementation of anti-dumping policies can also adversely affect domestic industries. Although these measures are designed to safeguard them, they can unintentionally result in monopolistic inclinations, especially in marketplaces where a single domestic producer holds a significant control. In the absence of competition from imported goods sold at low costs, domestic manufacturers have the potential to increase prices, which would negatively impact consumers and disrupt the balance of market forces. Nevertheless, the consequences of anti dumping actions go beyond the dynamics of trade. These actions can result in significant repercussions for local industries and employees. Although these measures provide short term protection for domestic firms, they may impede their long term global competitiveness by shielding domestic producers from direct competition. This might lead to unemployment and a decrease in the value of assets for domestic companies. Anti dumping regulations have a notable impact on trade diversion. As the prices of imports from specific nations increase, there is a possibility that consumers will shift their preferences to imports from alternative countries, resulting in alterations in trade patterns. Exporters from non targeted countries can derive advantages from this, resulting in changes in global trade patterns. Research conducted using European data has highlighted the substantial influence of anti dumping policies on trade patterns. The implementation of taxes has led to a significant fall in import volumes from targeted nations, while imports from non targeted countries experienced a rise. This leads to restructuring of international trade relationships. Thus, the conflict between the interests of producers and consumers is a primary focus in the discussion surrounding anti dumping measures. Although the primary objective of anti dumping regulations is to safeguard domestic sectors, they frequently lead to elevated prices for consumers. Another point that is required to be highlighted is that under the anti-dumping agreement provisions, public interest considerations are not required to be taken into account before imposing anti-dumping duties. The only consideration is the shielding of domestic producers, and the public interest doctrine has not been incorporated. Although there were talks in the Uruguay round regarding the inclusion of a public interest clause in the anti-dumping agreement, these measures were ultimately excluded from the final agreement since there was no agreement among the parties involved. Therefore, there may be cases when dumping and harm are proved, yet the benefits to consumers from reduced prices greatly exceed the losses incurred by the producers. According to the public interest norm, obligations can only be imposed when they serve the greater good of society. The current regime of antitrust duties does not permit this consideration to be necessarily taken into account. It should be noted that the European Union basic regulation on anti-dumping has made the community interest clause mandatory, although Indian law does not impose this need. Further, the anti-dumping agreement's injury concept only takes into account the harm done to specific domestic industry sectors. It does not take into account factors like consumer or national welfare. It ignores the effects of anti-dumping measures on the entire economy when it focuses only on the profit or loss to a few domestic producers. Moreover, the guidelines for determining harm are vague. Crucial factors like variations in market rates, depreciation of the value of the currency, or increased competition from local producers are not given enough weight. It is important to emphasize that anti-dumping regulations are primarily aimed at protecting domestic producers, and consumers are not the primary focus of anti-dumping regulations. Whereas all major economies around the globe have also enacted antitrust laws where the major focus is the welfare of the consumer. This takes us to understand and analyze the interface between anti-dumping and antitrust law. Unlike anti-dumping regulations, competition law aims to enhance consumer welfare and market efficiency. It must be noted here that although the rules pertaining to competition protection and anti-dumping share the same origin, they fall into two very separate categories of legal frameworks. They are similar in that they both seek to shield the market from unfair commercial practices, but their philosophical approaches are quite different. International trade and commerce are addressed by anti-dumping laws, which are implemented with the intention of shielding domestic manufacturers' interests from foreign producers' exploitative tactics. On the other hand, competition laws aim to safeguard the interests of the general public by fostering healthy competition in the market, which may enable customers to purchase the highest quality goods at lower prices. Further, anti-dumping laws prohibit discriminatory pricing in two different nations as well as predatory pricing. However, antitrust law does not prohibit discriminatory pricing if it results in consumer welfare. The correlation between anti-dumping investigations and competition law has been a topic of legal examination, particularly in cases such as Haridas Exports versus Float Glass Manufacturers Association. The court observed in this case that anti-dumping laws are designed to safeguard domestic industries, whereas competition law is intended to enhance consumer welfare and market efficiency. However, the two legal systems frequently function independently, resulting in difficulties in reconciling the interests of consumers and producers. There is another aspect of the matter that is required to be understood. There may be cases where there may be inaccurate assessments of injuries that might result in the unwarranted imposition of anti-dumping tariffs, as pointed out by the Indian courts in Bridgestone Tire Manufacturing versus Designated Authority case. This kind of imposition would ultimately disadvantage domestic consumers without effectively safeguarding domestic producers. It is interesting to note that while competition law seeks to promote economic efficiency by maintaining market competition, anti-dumping regulations are unaffected by the question of economic efficacy. Competition law's main objectives are to protect businesses from unfair competition and to ensure that insofar as these regulatory frameworks permit it, the real functioning of decentralized markets will promote both static and dynamic economic efficiency. However, the protection of domestic manufacturers is the cornerstone of anti-dumping legislation, which places less emphasis on economic efficiency. After having discussed the dumping and anti-dumping laws, let us examine some anti-dumping investigations in India pertaining to essential goods. Upon closer analysis of previous cases, it becomes evident that there is a worrisome pattern. Anti-dumping investigations generally prioritize safeguarding domestic companies, often disregarding the welfare of consumers, especially in situations requiring vital healthcare supplies. In the specific example of anti-dumping investigations concerning imports of acetone originating in or exported from Korea and Russia, the inquiry primarily concentrated on the harm caused to domestic businesses without sufficiently considering the potential consequences for consumers. Acetone, an organic compound used in the pharmaceutical industry, was sold in India at a lesser price than the normal price, and there were Indian producers manufacturing the same. It resulted in the implementation of anti-dumping tariffs. Although consumer concerns about getting cheaper medicines required greater emphasis, since the right to health is a fundamental right under the Constitution of India, they were mostly disregarded during the examination. Similarly, anti-dumping inquiries were initiated on a matter instituted by Bajaj Healthcare regarding the import of vitamin C from China. As we understand, vitamin C plays a crucial role in numerous medications and supplements, particularly in the context of COVID-19 pandemic, due to its ability to enhance the immune system. However, the examination by the anti-dumping regulator did not consider the extent to which consumers depend on vitamin C and how it affects the availability and affordability of crucial healthcare supplies. Therefore, the existing structure for anti-dumping investigations in India does not include mechanisms to consider consumer welfare in addition to the harm caused to indigenous industries. Investigations primarily prioritize the evaluation of harm inflicted on local producers while neglecting the wider social consequences. It must be remembered that the judicious integration of consumer interests into these investigations would empower the authorities to make more enlightened judgments that harmonize the requirements of both producers and consumers. Now, let us conclude the topic. From the foregoing discussion, it is evident that in discussions surrounding anti dumping regulations and their implementation, there is a dichotomy between the interest of the producers and the interest of the consumer. Anti dumping rules initiated to safeguard local producers and ultimately the consumer in the long run may initially safeguard producers by deterring unfair pricing practices. They can ultimately foster monopolistic behavior and result in elevated prices over time. Anti dumping regulations may shield the domestic manufacturers from lower pricing by foreign entities. However, the consumers may face increased prices and limited access to necessary commodities. Therefore, anti dumping regulations have a significant impact on consumers, especially in the case of vital items like healthcare products. The Commissioner of the International Trade Commission, Janet Nazem, in 1995 summed up the effect of anti dumping policies. She commented, "It must be remembered that the purpose of the anti dumping and countervailing duty laws is not to protect consumers, but rather to protect producers. Inevitably, some cost is associated with this purpose. However, unlike the antitrust laws, which are designed to protect consumer interests, the function of the anti dumping laws is indeed to protect firms and workers engaged in production activities. So, it should not come as a surprise that the economic benefits of the remedies accrue to the producers and the economic costs accrue to the consumers. Therefore, it is necessary to consider the immediate advantages of anti dumping policies with their potential long term effects on consumer well being. To achieve a harmonious equilibrium between anti dumping regulations and consumer welfare, it is necessary to revamp existing methods to take into account the wider social consequences. There is a need for having a harmonious equilibrium between protecting domestic sectors from unjust competition and guaranteeing customers the availability of reasonably priced goods, while ensuring the protection of indigenous producers is crucial. The anti dumping must provide for a detailed evaluation of the effects on consumer welfare and market dynamics. It is essential to include consumer concerns in anti dumping investigations to establish a trade environment that is just and fair. The current surge in anti dumping cases targeting critical products underscores the pressing necessity to revamp existing frameworks to consider consumer well being more effectively. By including consumer interests in anti dumping proceedings, authorities can make better informed decisions that strike a balance between the requirements of producers and consumers. Ultimately, attaining a balanced state of protecting domestic sectors while also guaranteeing consumer well being necessitates a collaborative behavior from policymakers, regulatory entities, and international institutions. By amending anti-dumping legislation to incorporate consumer interests, we may establish a just and comprehensive global trade framework that advantages all parties involved. To summarize, the convergence of consumer interests and anti-dumping rules creates an intricate terrain filled with difficulties and possibilities. That is it for the time being. Thank you very much. Happy learning. God bless you all.